if they can hear us.
Yeah, I can hear them too.
Oh, there we go.
We are ready to get started, Chair Edge.
Okay, am I waiting for a red light or are we good to go?
The red light is on.
Excellent. Good evening. I'd like to call the meeting to order and welcome you to the regular meeting of the Milwaukie Planning Commission. Agendas and additional copies of staff reports are available on the city website at www.milwaukieoregon.gov. You may locate them by navigating to the community calendar where tonight's meeting page is posted. If you have not reviewed the agenda, please do so. It contains important information about the process. First up is Native Lands Acknowledgement. The city of Milwaukie respectfully acknowledges that our community is located on the ancestral homelands of the Clackamas people. In 1855, the surviving members of the Clackamas signed the Willamette Valley Treaty, also known as the Kalapuya, etc. Treaty, with the federal government in good faith. We offer our respect and gratitude to the indigenous people of this land. And in respect, I would like to take a moment of silence, please. Thank you. Moving on to the approval of the September 13th, 2022 meeting minutes. Does anyone have any corrections to make?
Joseph, can you hear me?
Yes.
Could you, we're having some volume issues here, and I'm wondering if perhaps it's on your end, if you could, I haven't previously experienced volume being a problem with your microphones, but you could.
Maybe.
Okay. Okay.
I can hear you fine.
Okay, just hold on a second. We're working on it here in the studio.
Okay.
Turn up the radio.
Let me know if you need me to say anything or move forward.
Thanks everyone for your patience. It was working earlier, it's just not working now, right? That's the way it goes. So he's trying to figure it out for us. It's technology.
Did you suggest that?
There are things that I realized. Don't make suggestions. True.
I saw Lauren at the grocery store. She didn't say she was going to be here.
Death in the family.
Oh.
Yeah.
That's sad.
Yeah.
How much What are you saying that every NDA gets?
Attendance,
No, gets like a year for spending.
$4,000.
The,
Rich, do you want to give it a shot? Do you want to say something?
Joseph, could you give us a mic check?
Yeah, how does this sound?
It's the same, unfortunately.
Speak really loud.
Gonna turn it up a little.
Am I exceedingly quiet?
Yeah, you're rather quiet. It's very hard to hear you.
Hey, Jekko, can you hear me too? Or is it
Josh,
just Joseph?
you sound great. So maybe
Yeah, Jacob, move closer to your mic, brother.
I do sound pretty good.
Well, maybe you want to chair the rest of the meeting then, Josh.
throw 'em in.
Has my sound improved at all?
It's getting better.
Really? Okay, well,
There it is.
yeah.
Yeah, that's a little
Yeah.
better.
I think my phone provider was interfering with that. I switched off my Wi-Fi and suddenly my sound is better. So, all right, well, let's move forward. Moving on to the approval of the September 13th, 2022 meeting minutes. Does anyone have any corrections to make?
No.
Hearing none, I will entertain a motion to approve the minutes as presented.
Chair, I would like to make a motion to accept the September 13th, 2022 minutes as presented.
I'll second.
I have a motion and I have a second. All those in favor, please raise your hand and say aye.
Aye.
Aye. That looks unanimous, so thanks everybody. Are there any informational items from staff?
I will just say it's election day, as if you didn't know that already. So I hope everybody got out and voted today. And also, I just wanted to say that the city offices will be closed on Friday in honor of Veterans Day. So I'd like to thank all of those that have served over time here for the United States.
Thank you, Laura. So this is an opportunity for the audience to comment on items that are not on tonight's agenda. First, do we have audience members in attendance?
Yes.
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 Yeah, we do.
Okay. Does anyone wish to comment on an item that is not on tonight's agenda? And if participating virtually, please use the raise your hand feature in Zoom to indicate that you wish to make a comment. If anybody's on phone, that would be dialing *9 to raise your hand. Do we have any takers?
There's no one here in the audience that wishes to speak at the moment.
It doesn't look like there's, it also does not look like there's anyone online.
Okay, excellent, thank you. So we'll move to the CIAC. At this point of the agenda, the Planning Commission will act as the Community Involvement Advisory Committee. I now ask staff to provide any updates.
I just wanted to let you all know that I will come prepared at the next meeting to do kind of a follow-up on all of the to-do items that came out of our joint meeting with the NDAs on October 11th and kind of have a little plan for how we start to think about rolling some of those things out next year. So I'll bring that back to you at the December 13th meeting.
Well, thank you.
Chair, if I may make a comment.
Yes, please.
I made a complaint with a solution about the TSP process, and I want to thank the planning department and the engineering department and city council for taking a pause and relooking at the public engagement portion of the TSP. And I sincerely appreciate the council and the planning department listening to the residents of the city and asking for more involvement. So thank you very, very much for that.
Thank you, Commissioner Hemer. Do CIAC members have any items to report? Okay, then does anyone in the audience wish to speak with the Planning Commission in their role as the CIAC? Again, if using Zoom, please use the raise your hand feature to indicate that you wish to make a comment or dial *9.
Chair Edge, there was a number of confused faces about your question of the CIAC. Do you want to maybe take a quick moment to explain the Community Involvement Advisory Committee?
Yeah, this is a different role that the planning commissioners serve for the city. Our comprehensive plan policies call for a community involvement advisory committee, and that is us. And so we take time out of every meeting to make sure that we are engaging the community and giving you an opportunity to speak with us about community involvement with the city, with the land use planning and application reviews that the city undertakes. So this is not relating to anything on the agenda later, but it would represent an open forum where members of the public could speak to us generally about community involvement in these processes. Do we have anybody that wishes to speak?
Doesn't believe we do. Thanks for the description.
Thank you. So next up is our hearing item, which is a conditional use for a vacation rental. And so let's see, the next agenda item is a hearing on a vacation rental conditional use. The public hearing on vacation rental conditional use is called to order. The purpose of this hearing is to consider application number CU-2022-003. The purpose of the application is to request a conditional use on property located at 4843 Southeast Barbara Lynn Way. The applicant has the burden of proving that the application is consistent with the City of Milwaukee's zoning and subdivision ordinance, comprehensive plan, any applicable municipal code provisions, and that the proposal conforms with all the city's applicable criteria. I now ask staff to cite the zoning ordinance sections where the criteria can be found.
Thanks, George. The applicable sections are in MMC 19301, 19905, and then 19006.
Thank you. All testimony and evidence must be directed toward the applicable substantive criteria. Failure to address the criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes appeal to the City Council based on that issue. Failure to raise constitutional or other issues related to proposed conditions of approval with sufficient detail to allow a response precludes an action for damages in circuit court. Any party with standing may appeal the decision of the Planning Commission to the City Council. Persons with standing are those who submit comments or testify. We will recognize those persons submitting testimony. Please state your name and city of residence for the record so that they may be entered into the minutes. If you are here to testify, please remember to confine your remarks to the application and the relevant criteria, and to avoid repetition and information not relevant. The moderator may mute you if disruptions occur. If additional documents or evidence are provided by any party, the Commission may, if requested, allow a continuance or leave the record open to allow the parties a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitations of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. Does any member of the Planning Commission wish to abstain from this hearing?
No.
No.
No. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest?
No.
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 No. Does any member of the Planning Commission wish to report on any ex parte contacts?
No.
No.
No. Okay. Will any commissioner who has visited the site prior to the hearing please raise their hand? Thank you. Did any of those commissioners who visited the site speak to anyone at the site or note anything different from what is indicated in the staff report for this application?
No.
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 No. Does Does any member of the audience wish to challenge the participation of any member of the Planning Commission? Taking that as a no. Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter?
No.
Also no. Okay, thank you. Let's proceed to the staff report presentation.
Great. Thank you. Hold on one second while I share the presentation. Is the presentation visible on Zoom?
No, I'm not seeing it yet. Oh, there we go.
Yes. Okay. Thank you. So tonight we're looking at a conditional use application for a vacation rental. The address is 4843 Southeast Barbara Lynn Way, and the case file number is CU 22-003. To give you an overview, this property was developed in 2020 with a single unit dwelling. The lot is just under 8,000 square feet and is zoned RMD, which stands for Moderate Density Residential. The house is part of the Cheragino Farm subdivision, which was annexed into the city of Milwaukie in 2019. You can see here the vicinity. Most properties are also zoned moderate density residential, and there are surrounding the subdivision is primarily unincorporated Clackamas County. The property under consideration here is outlined in red. To start with the definition of what a vacation rental is, we make a distinction in the Milwaukee Municipal Code between a short-term and a vacation rental. That distinction is primarily around owner occupancy. Short-term rental is considered a home occupation, and the occupant of the house lives there for at least 270 days per calendar year. For a vacation rental, the difference then is that the owner of the property does not live on site for 270 days per calendar year. So in this case, the owner does not live on site. So this is a application for a vacation rental, which in the moderate density residential zone is allowed as a conditional use. So looking at the approval criteria for a new conditional use, which are outlined in MMC 19905, staff believe that of the 7 approval criteria, all must be satisfied, but 3 in particular are relevant to this application. So that's number 2, the operating and physical characteristics of the proposed use are reasonably compatible with nearby uses. Number 3, all identified impacts will be mitigated to the extent that's practical. Number 4, the proposed use will not have unmitigated nuisance impacts that are greater than those that would be typically generated by a use that is allowed outright. So in this zone, that's mostly residential uses. Looking at the application, and this is outlined in more detail in the staff report, staff believe that the proposal meets the approval criteria for a few reasons. Looking at the first one, operating and physical characteristics of the proposed use. The applicant isn't proposing any physical alterations to the property. It'll still maintain the appearance of a single unit dwelling. The property is mostly marketed towards family rentals. Going on to the second one, all identified impacts will be mitigated to the extent that's practical. So the owner lives nearby, lives in the Cherokee Farms subdivision, so is available to address any issues that could arise through a rental. They have installed cameras to monitor noise levels. The rental agreement kind of outlines all of these provisions. They have quiet hours from 10 to 7 a.m., 10 p.m. to 7 a.m. that they'd be enforcing with the assistance of those cameras. The rental agreement is also including things like there's an age restriction on who can rent the vacation rental, so you have to be at least 25 years of age. The total number of guests is limited to 10. The sample rental agreement disallows pets. It disallows smoking on the property, and it disallows on-street parking. The proposed use, staff believe, looking at sort of holistically that rental agreement and all of these provisions, the existing development on the site, that there are 6 off-street parking spaces, 3 in the garage and 3 on the driveway. Staff believe that the proposed use doesn't have nuisance impacts that are greater than what would be permitted outright, which again is a mostly residential uses. Any questions about any of those? No.
There's only one thing. We do allow pets. That's one thing, sorry.
Noted. Thanks. That.
Only good ones.
No. Okay. So staff did receive some public comments. 2 of those were from the land use officials with the NDA. No position was taken. Those were just clarifying questions that were submitted to staff, and those are included in the staff report as well. And then we did receive 1 comment from a neighbor in the Cherokee Farm subdivision, Nancy DeBoard, who was in opposition to the proposal. So there are 4 options. 1 is to approve the application with the recommended findings and conditions of approval. 2 is to approve the application with additional modifications to the findings or the conditions of approval. Those modifications would need to be read into the record. 3, to continue the hearing, and 4, to deny the application. The final 120-day deadline is January 7th of 2020. That's a mistake, 2023. Staff recommend approving the request and adopting the recommended findings with a modification to one of the findings that was in the staff report. So specifically finding for section, I guess it would be finding number 6, sub point A, number 6. So I'll just discuss what that is about. So it has come to staff's attention that one of the applicable, sorry, let me start that over. There is one of the approval criteria requires that the proposal comply with the goals and policies in the comprehensive plan. Staff identified a policy related to economic development and the sharing economy that we currently believe is actually, upon consideration, less relevant to this proposal, and that there is in its place a more relevant goal and policy, and that's housing affordability, and specifically policy 7.2.9, which is to monitor and regulate vacation rentals to reduce their impact on the availability and long-term affordability of housing. Staff believe that the proposal complies with that by the very fact that we have adopted into our zoning code a process, i.e. the conditional use process, review process to review and approve vacation rentals. So I would simply say staff's recommendation is to adopt the finding with this amendment. Adopt the findings with this amendment. That concludes the staff presentation. Open to questions.
Thank you. Are there any questions for staff? Any clarifying questions from the commission?
Chair, if I may,
Please.
how much control does the city have over the rental agreement? So if the rental agreement changes after we approve this, does it actually stop the conditional use?
Justin, can you answer that question?
Certainly the form that they use, I don't think the city would have any jurisdiction over the actual form they use, but rather the terms that are in the form. Like if the quiet hours weren't being maintained, the material elements of the form of application change, and we start to see noise at an earlier time, or I guess I was believing that it was no pets, but I think we had a clarification from the applicant that there were going to be pets involved. So that one's not appropriate. But if there was parking on the street, I believe the elements that are going into the approval are that they're not going to allow off-street parking. So I think you use the draft application to provide kind of the nuts and bolts behind what use they're going to make of the property. Does that make sense?
Yes. So it does, by the lease that they are presenting, it locks in the lease for the lifetime of that property for that conditional use.
Yeah, but I mean, like I said, the actual piece of paper they sign, whether they change the terminology or use a different form might not change, or might change, but the actual rules by which they rent.
The 25 years or older.
Exactly.
10 people or less, right? The parking, that all gets locked into this if it's approved tonight.
And of course, conditional uses are typically, when somebody's not using their approved conditional use in a manner that it's approved, that comes to us via complaints. So if 24 people are renting this place out and there's a complaint filed, that would trigger the code enforcement officer to come out and take a look and see what we've got going on there. And staff will look at the overall conditional use approval to determine whether or not they're complying with the terms of the approval.
Okay, thank you.
An analogous situation might be a conditional use for a ball field. The lights are only allowed to be on for certain hours of use, right? If the lights are on a bunch of other hours, neighbors are going to complain about that. That triggers the process to review the conditional use to make sure the use is consistent with the approval.
And then is that, just as a follow-up, is that conditional use, aside from code enforcement, which could happen irregardless of a conditional use, right? If you're playing loud music all the time and other sorts of things, there's code that handles that.
Absolutely.
But I would anticipate that at some point that conditional use could potentially be revoked by the city.
Indeed, it can be.
And just another kind of follow-up question that I am hoping to understand is, if and when this conditional use is granted, is that then, if the property owner, for example, sells the property, does that transfer to the new purchaser of the property? When or until it's terminated?
Yeah, I believe it does, but I don't know specifically the answer to that question.
Okay. Thanks.
Are there other questions for staff from the commission?
No.
Okay, I have one question, and this one is for Justin, probably. I just wanted to clarify with you that CC&Rs that might apply to this property do not, in fact, are not part of our approval criteria. Is that correct?
Yeah, let's see, yeah, CC&Rs are under Oregon law and most other jurisdictions that I'm familiar with, CC&Rs are essentially a contractual arrangement and the city's not a party to that contract. So the city doesn't have any duty or ability to enforce the terms of a CC&R.
And so if there were CC&Rs applicable to this particular use on this particular property, that's not part of our criteria that we are considering here today.
No, CC&Rs aren't included in the code requirements for an application, nor are they a responsibility for the city to enforce.
Okay, thank you for clarifying that. Appreciate it. Have we received any correspondence on this matter other than those items included in the meeting packet?
No, outside of the ones included in the meeting packet and then the one that was received today that was sent to Planning Commission.
Okay, thank you. Would the applicant or their representative like to comment?
Yes.
How long of a comment and how appropriate? I wasn't sure how to prepare.
3 minutes.
What, 3 minutes? Okay, great. My name is Justine Syke. Thank you for your time this evening. I'm a single woman and I work in real estate, which income is very variable, especially in shifting markets. I purchased 2 properties in the Carragino farm development because I love living in the neighborhood and I wanted to turn one into an investment where I'd be on hand to monitor it. And I think the neighborhood's great. I've invested over $130,000 in purchasing, furnishing, landscaping, getting this all ready to go, and about $3,700 in total to acquire the permit. I had to have someone help me with some things. I've studied the criteria for the permit and it appears that I meet it all. I know that this isn't pertinent, but the HOA CC&Rs have 0 restrictions on any type of rental, whether long or short term. This is my assistant and friend, Nick, and he lives 4 minutes away and he manages with me. So in the event that I was not available, he's available. He also has a partner who can step in just to ensure that no disruption or anything persists and we can take care of it right away. I'm on the board of the HOA. I love being part of this community and thank you very much.
Thank you. I was going to ask if any of the commissioners might have clarifying questions for the applicant. I do not see any hands raised. So thank you very much for your testimony. I appreciate it.
Thanks.
Sorry to make you come back to the table.
Sweating, it's all good.
Okay, so now this is for testimony in support of the application. Do we have anyone who wishes to speak in support of the application?
Can someone that's not a neighbor speak?
Any member of the public is allowed to speak.
He's too shy. Never mind.
There's no one.
Okay. Do we have anyone who wishes to speak in opposition of the application?
Yes. Yes, we do.
Yes, we do.
Okay. Each person who will testify will have 3 minutes. And please limit your testimony to the relevant criteria and please try to avoid duplicative testimony and repetitive testimony. Thank you. When you start speaking, please introduce yourself, first and last name, and the name of the city that you reside in.
Lynn, do you want to come up? Sorry, I don't know your last. I don't know your last name. Shoemaker. Okay, thank you.
My name is Lynn Shoemaker, and I live at 4829 Southeast Barbara Lynn Way, which is directly adjacent to the applicant's property. I also sent a letter along with my wife on November 1st that we both signed. Did you guys get a copy of that?
Ryan?
I sent it to Ryan Dyer on November 1st.
From Lynn Shoemaker, did you receive the letter and forward it to the Planning Commission?
Physical letter?
Yeah.
I did not receive that.
Okay, well then, I only have 3 minutes, so I'm going to do my best to read this as quickly as possible so I can read it into the record. Okay? Dear Mr. Dyer, we received a notice of public hearing regarding Justine Sykes' request to use her house as a vacation rental. We own the single-family home that is directly adjacent to that house, and we've been very concerned about Justine using this home as a vacation rental instead of a single-family dwelling. We bought our house in March 2021. We read the HOA rules that we were told would be going into effect once the final houses were sold. These rules were given to everyone who bought a house in our development, including Justine. One thing the HOA rules said was that none of the homeowners could operate a business out of their house. All of the people who bought homes in the development received the same HOA rules that we did. And so she must know that doing a vacation rental is not permitted, and that's under Declaration of Covenants, Conditions, and Restrictions for Cherokee Farms, item number 10. No portion of the property shall be used for business or commercial purposes. We share a common fence with Justine's property, and we bought our house at the same time Justine bought her house in March of 2021, and she lived in that home until a couple of months ago. We bought our house as a single-family home, and the neighborhood is one of single-family homes. No apartments are present, and there are no homes that are hotel spaces. Justine told us that she had purchased a second home in our development, and she planned to use her original home at 4843 Southeast Barbara Lynn Way as a corporate Airbnb. We feel that we've been misled about who would be renting the house, and it's clear that this house is being used as a vacation rental, evidenced by the number of people staying in the house and the number of children and pets staying there, and the fact that most renters are staying only a day or two. We moved from Northeast Portland because we did not feel safe there, and we thought our new neighborhood would be safe. With the comings and goings of all the different groups of people at Justine's vacation rental, we don't feel safe in our own home. It's important for us to have neighbors that we can get to know and who will pay attention to what their neighbors are doing so that we will all notice when something is amiss. It's impossible to have the safety net when new groups of people are coming and going on a weekly basis. We're both retired women in our late 60s, and we deserve to be safe in our retirement years. Some of the specific events that have caused us to be concerned about Justine operating a vacation rental are: the vacation rental home has 3 or 4 different groups of people renting the property per week since Justine started renting the home out for short-term rentals. It appears that she is operating a hotel because she has so many different groups of people renting the property per week. And I reference ORS 699.005 for definitions of what a hotel is. On several occasions, the short-term renters have had large parties in the backyard of the rental house, which are loud and which have disturbed us and caused our dogs to bark for several hours. The third point is the vacation renters frequently have 2 to 3 cars in the driveway of the home, and often are several additional cars parked in front of our home and across the street, which prevents us from parking our cars on the street when we need to do so. We have resorted to installing a small garden fence to prevent people from stepping on the flowers that we've planted in our parking strip. At times, the vacation rental vehicles have been in various states of repair. On at least 2 occasions, 2 young boys, about 8 to 10 years old, were attending parties at the home and climbed up on the retaining wall in the backyard of the vacation rental home and climbed up on our fence. The fence separates our yard from the vacation rental yard, and the boys were looking into our living room windows, sliding glass doors. On another occasion, 2 renters were leaning over the fence into our yard and were having a conversation with each other about our dogs, and they were looking into our living room through the sliding glass door, which caused our dogs to bark loudly. Lynn texted Justine about that incident, and she said that she would put a stop to it, but we never saw her come over to talk to the people. In conclusion, while we're do not oppose Justine using her house as a long-term rental property for a single family, we are opposed to living next door to an Airbnb. With the shortage of housing in this area, it makes sense that Justine could rent the home out to a single family if she's not going to be living there. And it's signed by Lynn Shoemaker and Michelle Fusco, who's my wife and who is the co-owner. Would you like a copy of this, since you haven't apparently received it in the mail?
Yeah, we haven't seen it. I am sorry.
Yeah, I'm really sorry that you were that your letter wasn't received and shared with the commission before, but I was happy to give you the time to read that into the record today.
Okay.
Are there any questions from the commission? Any clarifying questions?
Chair Edge, I have a, maybe since this person spent most of their time just reading that in, I didn't know if there was anything else you might have wanted to share.
Yeah, the Cheragino neighborhood folks are pretty close. We have parties and we have gotten to know each other, which I think is really critical for our personal safety. So like, you know, there was a homeless guy that was wandering around and was rifling through people's recycle bins to take cans and whatnot. And, you know, one of our neighbors who happens to be here tonight actually observed that happening and mentioned it to people. And then another one of our neighbors who's here was talking to some other neighbors about trying to deal with this guy by having people not put the 5 cent per can deposit or 10 cents or whatever it is per can deposit cans out in the recycle bin and taking it into, you know, for one of those places where people could get money. And so, I mean, we solve problems. We work with each other. We know each other. And several of the folks that we know are here tonight as well. And I think that when you have people that are kind of randomly coming in and out of that vacation rental, we don't know them. They don't speak to us. I've said hello when I've been out working in my yard to some of these people that are in the driveway. They don't speak, they don't respond. So, you know, there's no way to get to know these people. And, you know, maybe you guys aren't as old as we are, but we don't feel safe when there's all these people that we don't know who they are coming and going out of this house.
Chair, if I may.
Please.
Basically, there's a conditional use that says that there's 25 less than 10 people and that 6 off-street or off-site parking spots are provided and that there's parking in the driveway. Since you live next door to it and you have made obvious observations, do you think that that lease has been broken in the past, or at least the promises of that lease?
I do. There's no way for 3 cars to be parked in her garage, mostly because she has a sauna in there and a foosball table, and she's got a track, you know, whatever you call those, a treadmill in there. So there's no way for cars to park inside the driveway. So they're left with the driveway itself, which has got 3 slots, but there's been plenty of times when there's, like I said, more than just 2 families or 1 family that are there, and they're parking their cars out on the street, including in front of our house. People are getting out and they're stomping on the flowers that are in the parking strip around the tree that we have. And so, yeah, there's not room for 6 cars to park there.
Okay, thank you.
Sure.
Additional questions from the commission? Okay. Thank you very much for your testimony. We appreciate hearing from you.
Thank
tonight.
you.
Do we have additional members of the public who wish to testify? And at this point, we are taking testimony in opposition.
Chair Edge, we do have one more gentleman here to testify, Charles Olson.
I want to ask questions. I don't know if that's testifying or not. Is that included in that?
Please come to the microphone and state your name and city of residence, and then you know, you feel free to ask questions of staff.
Thanks. Hi, I'm Charles Olson, and I live in Milwaukie, down the street from a lot of people in this room. And I just have a couple of questions. So I'm trying to figure out, why is a conditional use permit issued? Is it because there's some variance from city codes that needs to be done, or why? What makes the need for a conditional use permit?
Yeah.
Do you want me to take this one, Ryan, or do you want to take it?
You can take it.
Okay. So in this case, we have a policy in our adopted comprehensive plan that says that we should regulate vacation rentals to protect affordability of housing in the city. So the goal for that is to limit the number of vacation rentals so that it's not impacting, availability of long-term housing for people in the city. So that's why we have a conditional use, is because we need to make sure we recognize that this kind of use could work against some of our adopted goals. And so we want to make sure that we're reviewing these cases so that, we're able to make sure they're not impacting the city's ability to meet its goals.
And I would just add, if I may, that generally speaking, conditional uses are those land uses that have been identified that could be appropriate for a zone, if subject to certain limitations and conditions that are applied to that use. So when we're talking about conditions of approval through a conditional use process, those are the guardrails that Planning Commission has the opportunity to apply to a conditional use, essentially acknowledging like this might work, but let's put some guardrails on it through these conditions of approval.
Okay. So I've been, it sounds like a vacation rental is considered residential use, or is it not?
It is considered to be an accessory, or I guess in this case, it's considered to be more commercial in nature.
So it's considered a commercial use.
Yeah.
So the neighborhood's HOA codes and covenants restrict non-residential and commercial use. So would it be up to the HOA to sue? Or there's no enforcement by the planning department? Is that true?
That's correct. The city does not enforce HOA requirements or covenants and restrictions on development. That's a private contract. If you can imagine, CC&Rs often contain a variety of restrictions on property. A simple, innocuous one is in some places, they require you to bring your trash container in by 10 a.m. the day after the trash gets picked up. The city
I just want to make sure that's
the city would not enforce that. That would be something that, and this will get to my next point, that would be something that the HOA or an individual could bring an enforcement action. CC&Rs typically include some sort of mediation process to where you're as a homeowner, you have a required, and I'm not knowledgeable of the process in your particular CC&Rs.
Yeah, I understand.
Those are the types of things that are handled. I don't know that a lawsuit isn't 100% necessary, but it can mature into that, certainly.
So the Planning Commission won't take any CC&R stuff into consideration, even though you know it's going to cause troubles.
Correct.
Okay.
Yeah, if you can imagine, the Planning Commission is not a judicial body that interprets the terms of a contract and whether a contract's valid. That's a judicial remedy for the circuit court.
Okay. And my last question was, it appears that the ad for this property says it sleeps 12, but the limit is 10. So is it just a matter of getting the ad changed?
I expect that. Yeah. So I have not seen that ad, but I can say that one option for Planning Commission in adopting the conditions of approval would be subject to the terms in the sample rental agreement, which does limit it. They could essentially, Planning Commission could decide to limit the number of folks that can rent it to 10, to cap it at 10.
Great. Thank you very much for your time, y'all.
Thank you.
May I respond to these guys?
Isn't there a moment in our process for the people?
Sure, yes.
The answer is
Do we have
yes.
others who wish to testify in opposition?
Chair Edge, I just want to see if anyone in the audience on Zoom is raising their hand and would like to testify this evening. I want to give them a few seconds to respond. All right, I am not seeing hands raised on Zoom. Thank you.
Okay, thank you. And let's see, do we have anyone who wishes to offer neutral testimony?
Do not see anyone that wants to offer a neutral testimony.
Okay, and then just one last check. Does any member of the Planning Commission have questions regarding the testimony to this point?
Chair Edge, I do, if I may.
Okay, please.
A question for staff. I think in some of the written testimony we received, as well as what we heard tonight, there was reference about the fence and the fence being climbed over. And I was just curious, is the fence solid? Thinking about privacy and how tall is the fence? Those are just some questions I had as thinking about impacts.
Can I respond to that? Sure, the fence is 6 feet.
Sorry, you have to come up to the microphone or else nobody else can hear you.
The fence is a solid cedar fence that's 6 feet tall.
Thank you.
Chain link.
Okay, now this is the opportunity. Does the applicant have any rebuttal or any additional comments in response to the public testimony?
Sorry, Chair Edge. Just another question for staff or for anybody who's testified.
Please, yeah.
Is there any there was a reference to climbing up the rock retaining wall, which I think you could see in some of the pictures. Is there any landscaping or other screening that's in place, natural screening that's in place there? Doesn't appear so from the photos, but
yeah,
I just don't know if those are old or.
It's just the blocks and then the landscaping goes up. I'd be happy to add something so that there's no future issues though. So I wanted to respond to a few things. One is that I have done a lot of research on the CCNRs, and I know that's not your purview, but because the neighbor brought it up, I have an email from an attorney named Michael Beal that states, in response to the question, do Airbnbs fall under commercial use? He states, and I quote, no, courts have consistently ruled that short-term rentals are residential use, not commercial use. I'd be happy to provide that email to you. Also, there's a House bill that was passed, 2534. It'll go into effect on December 31, and it states, a condominium that includes units for residential purposes or planned community, including a community not subject to ORS 94550 to 94783, may not include in a recorded instrument governing the community and may not enforce any provision that would restrict the use of the community or lots or units of the community because of race, color, religion, sex, sexual orientation, national origin, marital status, familial status, source of income, disability, or other number of individuals. Also, I'm a little upset because Leanne definitely did not speak truthfully. There's been no parties. I've had no complaints from any neighbors, period. The only text I've ever had is from Michelle about the fence. I immediately jumped all over it, texted the person, told them to please have their kids not climb on the fence. I'd be more than happy to hear these things directly from my neighbors so that I can make sure that they're not being upset or disturbed. But like I said, I've had one text and that's it. So
I have a question, if I can, and a comment.
Please.
Do you have any data on how many other Airbnb or vacation type homes are in the Milwaukie area? That's my first question. And then I just want to make a comment which does not have any bearing on my decision. But I do want to say, and I don't know why you've chosen and whatever your reason is, we really have to follow the code. So we've already discussed this, but we can't follow the HOA rules. We have to follow the city code, and whether this meets the city code or not, that's what our decision. But on a personal note, I have an aunt who has an adult Down syndrome an autistic son, and we've had challenges in the past with my other aunt dying. We had to gather the family together in an area, and because her adult autistic and Down syndrome son is nonverbal and also has bathroom challenges, Airbnbs really work the best for our family in hotels. And I know that I do understand so many of the challenges that can come up, which is why we have city code to address a lot of these things. And I also understand from a neighbor's perspective, having additional cars and traffic. So I understand a lot of the challenges. And again, we really have to base our decision off of city code. But I do appreciate, and I also understand the challenges that we have.
Commissioner
Yes. I'm done.
We're getting into a little bit more of deliberation than we are.
True.
So this is just a time to ask a question to the applicant.
Yeah, I'll circle back to the data question really, but I wanted to give some context as far as, and while you're up and speaking.
So I'm a realtor. So actually the original thought I had was to do a corporate Airbnb and like allow my my clients to stay there. I looked into a couple management companies and decided they were not the best and had bad reviews. So I decided to manage myself, and it allows me to allow my clients to stay there. And then additionally, it's been really fun to also host families. You know, I've had people come for weddings, funerals, just to gather, visit family. It's been, I do not want to cause my neighbors any harm. And I am very open to taking feedback and figuring out a solution to work together. But I think it's a really great property, and I've been really excited to run it. So I feel that I've complied with the rules, and I'm very open and amenable to adding fencing or doing things that will contribute to the well-being of the community.
And then just the data question, which was actually the relevant.
So there's, I think, only like 2 comparables in Milwaukie. There's the Milwaukie Playhouse, and then one other one. Most of them are pretty small, and one nice thing about having a larger one is that it's more affordable for families because they split the cost, and that's why I think it will have great success because of that. And it's an aesthetic, beautiful space, and there's not very many of those. Happy Valley only has maybe 5 total. I'm in the process of selling a lot of them to my clients because it's a needed thing, I think, to have destinations that aren't hotels. So.
Chair,
Are there additional questions from? Go ahead, please.
So during the public testimony, somebody said that you advertised for 12 sleeping. Is that correct?
I think that's on Airbnb. We can adjust that. I thought it was 10. We actually could adjust that right now.
Okay.
Would babies fall under that category? Because I've had that question.
I believe it's 10 people.
Okay.
Other questions from the commission? Okay, well, thank you very much for your testimony. So the public testimony portion of this hearing on file CU-2022-003, the vacation rental conditional use, is now closed. Is the commission ready for discussion?
Yes.
Yes.
Who wants to go first?
Chair, to help our discussion, may I request that the city puts up the 5 criteria again, please?
6 criteria.
6 criteria.
Or 7, actually. There's public transportation, number 7.
There we go, the 7. Thank you. Could you actually leave that sidebar up?
Sorry, I just wanted to make sure you could actually read.
Oh, thank you.
Yeah.
Who wants to go first?
Sure, I'll go first. And thanks, Commissioner Hemer, for encouraging us to bring this up. I was looking at it on my screen. You know, I think as I was looking through a number of the criteria and listening to some of the conversation here and the testimony, and want to thank everybody on both sides of the issue for coming out. I think I have some questions about some of what we've heard, you know, and thinking about things like operating and physical characteristics of the proposed use will be reasonably compatible with and have minimal impact on nearby uses. And in looking at the findings of approval, you know, there's reference to the 6 parking spots, which it sounds like while those 6 on-site parking spots might exist in theory, they might not actually exist in practice. And so that's just kind of one thing that I'm thinking about. Looking at the 3rd criteria, all identified impacts will be mitigated to the extent practicable. I think regardless of what we do tonight or don't do, there's a reference in the finding here about a no pets policy, which I think we've heard to not be true, so we would need to change that. There's also a reference to ample off-street parking. We might want to consider a change there. I think some of the issues with fences maybe raises privacy impacts that aren't kind of necessarily addressed here, which the applicant has said that she'd be willing to make some changes on. So those were just a few things that I'm kind of thinking about as I'm looking through this, and partially thinking maybe the applicant and people should talk a little bit more before we're making a decision on this. But those are some of my thoughts.
Is that something that Justin wants to opine on in terms of what our discretion is there?
I would prefer if you guys came to a decision today, just because I'm not certain that adding more time into it is going to be very helpful. I'm very willing to add additional fencing. I'd even be able to fence off the entire portions, but there'd be no access to the issue that was created with the kids looking over the fence. I can commit to that right now.
Oh, is Justin sitting there?
Oh, sorry. Should I come up? No.
No, I'm sorry, Justin. Sorry, our attorney.
No,
Just seen those.
Sorry.
that's okay. Just gonna let you finish. Remind me what you would like me to opine on, Commissioner Edge?
Kind of the discretion that we might have to apply conditions, you know, that relate to some of the things that Commissioner Sherman was raising that are kind of specific in the findings. You know, do we adjust the findings? Are these things that the findings really control? You know, in terms of the permit and how the permit, you know, will be enforced.
Well,
and yeah, go ahead.
The first one that comes to mind is the parking issue. Certainly, the applicant, and I believe through the draft lease, which the material terms will be incorporated into the conditional use. So if people are parking on the street, that's a violation of the conditional use. Call the city. In terms of the landscaping, I'm not familiar with I've heard testimony that the sign is 6 feet tall. I'm not sure what type of review is necessary to put a higher fence up in that location. I'm not that knowledgeable. I'm familiar with the neighborhood, not that knowledgeable with the actual fence. Of course, landscaping buffers, certainly something that a condition could be placed. Takes a while for those to grow. My immediate reaction to Commissioner Sherman's question about landscaping is it's a brand new subdivision. So a lot of things haven't been planted. Things that have been planted haven't matured. I suppose you could fall into a black hole of certain mitigation measures being taken that are articulated in the hearing tonight, but they don't meet the neighbor standards. And what standard are we actually setting? So you run into some difficulties there. Certainly privacy screening is something we deal with quite a bit in development. So we could probably work on trying to factor some sort of language. I don't know that we're going to come up with a perfect solution tonight, It also could be something where, and again, I'm not going to opine on the status of CC&Rs or HOAs or what's a commercial versus what's a residential use. Those are things for the court to sort out if it ever comes to that. There could also be some potential discussions between the applicant and the neighbors to see what sort of things would satisfy the neighbors to help arrive at those. Of course, it's within the commission's authority to continue the hearing if they feel that those questions could be answered by further communication with the neighbors and the applicant, with the applicant in the city, with the neighbors in the city to see if we can factor something in. I don't know whether that's an eventuality in this situation or not. That's my opining.
Okay,
Commissioner Edge.
Thank you. Thank you, Justin. I appreciate that. And I'd like to give the other commissioners opportunities to weigh in before we consider like a recess to allow some discussion between the applicant and staff. So other commissioners, anyone would like to go next?
Do you want to tell your story?
I just, again, will say that really you have to base the decision off of the code. And does this property, is it meeting the code? And that's what we have to base our decision off of. I appreciate the answer as far as there only being 2 other rentals like this in the city of Milwaukee, because I think that one of the main reasons that we even have people, if I understand correctly, coming in front of us to kind of go through and make sure that all of these this criteria is being met is so that we don't get overwhelmed with vacation rentals rather than long-term rentals. And so so knowing that there's only 2 or so other properties like this in Milwaukee, that seems reasonable.
So, yeah.
Thank you, Commissioner.
I'm sorry, Chair.
Please go ahead.
I would like to add on something as a conditional use to provide mitigation to alleviate climbing on neighbor's fence. I think that is probably simple enough of a statement that it doesn't necessarily set a standard, but it certainly sets an objective. I would like to see that on there too. No offense, but past history has a tendency to kind of prove performance in the future. And so the contract says 10, the advertisement says 12. We've heard testimony that parking has been on the street. So either the applicant is not necessarily willing to live within their own deals of the contract, or maybe this will be a wake-up call and that the residents have now a better understanding of what they can do to actually stop it. And so I'm teetering a little bit on this myself on the decision. So I would like to hear from other commissioners and maybe Chair Edge, if you're going to make a suggestion, that might not be the worst thing in the world too.
Thank you. Commissioner Freeman, would you like to say anything?
Thank you, Chair. I would just say, this is going to be a long-term relationship, and it doesn't seem like the community has had much dialogue. Whether this is going to be passed or not, there's going to be ongoing back and forth. I don't want to set up a situation where we would approve this and then the city's getting a call like every other day for problems. So I think there first needs to be some dialogue between the neighbors and the applicant to kind of figure out if this can be resolved. Thanks.
Yeah, thanks for your comments. So my where I am with this is that I believe that with the revision to the findings proposed by staff, with respect to condition 6A6, I think it was, that accurately reflects the facts in the record. However, we do have discretion in how we handle mitigation in terms of conditional uses. And so I appreciate the commissioners weighing in on that. And at this point, I would like to offer that we maybe have a 5-minute recess, and that maybe staff can connect with the applicant and see if a continuance is in the best interests of all involved, or if we can come to some reasonable mitigation measures that we could apply as conditions tonight, so that we can move forward as the applicant requested earlier.
I have a quick question.
Staff, do you think that sounds reasonable?
Can I have a quick question? As a condition,
Yes.
could we, I know this might seem opposite, but reduce the advertised parking spaces to 4 or 3, whatever's.
I will empty the garage.
Empty the garage.
Empty the garage. There will be 6.
Okay.
And yeah.
And then make it more clear. I mean, if that's conditional as far as, trying to meet and address all of the concerns of the neighborhood and the neighbors for parking.
And I think Commissioner.
I was just going to say, I think that we certainly could condition a number of parking spaces. I also think that we could also just condition the performance standard of no on-street parking.
Right.
And then that's up to the applicant.
The
how
applicant
they
to
use
say
their
4
space.
spaces or,
And that's exactly right. Yeah.
Okay.
Commissioner Hemer?
Yeah, and I just want to do we need to condition into Commissioner Sherman's point about the pets being allowed or not being allowed? I mean, I don't know how.
At the very least, we have to change what's in the findings of approval because it sounds like it's incorrect. So either the applicant needs to propose a change there, or we need to change that.
And that's where maybe the 5-minute recess could actually be effective.
Yeah.
Okay.
Thanks.
That's what I'm hoping.
It would also be interesting, as I indicated, though, I think, I feel like I have heard some privacy impacts that were raised, and maybe that's a topic to talk about during the 5-minute recess between the city and the applicant as well, if there is some mitigation there that could be thought of.
So just to restate our objective for the recess, the applicant clearly expressed a desire to have a decision tonight. And since we're considering whether additional dialogue might be necessary with the community, or whether we might be able to apply mitigation that would allow for a decision tonight, I'd like to recess to allow the applicant to have that discussion with staff to see if we can get some direction to let us know whether we revise our findings tonight or whether we continue the hearing.
And I want to make sure that staff thinks that 5 minutes is going to be enough for this discussion.
Seems more like
that's an open question.
10, maybe a 15-minute.
And I would like a discussion about providing mitigation to alleviate the climbing on the fence as well. I'll make a motion to take I'll make a motion to take a 10-minute recess.
Second.
Okay, all those in favor of 10-minute recess, say aye.
Aye.
Aye, unanimous. Okay, we'll come back at 7:54.
You're living in the future, man. Yeah, City Hall. That's right.
changing course. So if somebody is signing somebody else's stuff, then they don't, it's just
So
more
if
of
I
like,
track it and I know I didn't vote and somebody.
and somebody else signed it for you, or it's more of a, who signed this then?
Oh, right, because my name is on the ballot, right, with my address.
Right.
Right, that's on the ballot, or at least on my envelope.
On
It's
the
on my-
envelope. On the envelope.
Okay, Chair Edge, we're ready to start the meeting, I believe.
That makes sense.
Yes, it does.
Okay. Let me know when we're live.
We are live.
We're live.
Yes, we are.
Yes.
Okay, thank you. We are back. Is there any update from staff to inform our deliberations?
Yes. Staff were able to discuss some of the issues that were raised with the applicant and believe that we can recommend approval subject to some amendments to the findings and some amendments to the conditions of approval for the application. I can walk through those kind of one by one if that works.
Please do, yes.
Sure. So with regards to the parking, staff would recommend basically the sample rental agreement that was included with the application restricts off-street parking by folks that are renting the vacation rental. Staff believe that inclusion and adding a clause to the conditions of approval that essentially says that the application is approved so long as the sample rental agreement is the one that's used by the applicant. So that would, we would not be requiring a certain number of parking spaces. We would essentially be saying there is no on-street parking for this use.
Okay.
Moving on to the issue with the retaining wall and visitors climbing on that. The applicant has agreed to a couple of provisions that would be added to the conditions. One would be the inclusion of signs posted in the yard instructing visitors that there is no climbing on the retaining wall. In addition to that, the applicant has agreed to plant some mature vegetation along, I believe, the top of the retaining wall, sort of restricting access. We also discussed a fence because of the existing height of the retaining wall and the limitations in the county's development code, which is actually the code that applies here. There's a 6 foot height on height restriction on fences. Fences can be no taller than 6 feet. So it wouldn't necessarily work to place a fence on top of that retaining wall. Any questions about that? No. Okay.
Not for me. Anyone, commissioners, questions?
No.
Okay.
Yeah, and that's, I mean, those are basically the two primary issues that we discussed with the applicants. And again, I'll just reiterate that amending staff recommend approval with the amendments to those findings and the amendments to the conditions of approval.
I would only add the clarification that the discussion that we had with the applicant about signs would be that the signs would be placed on the fence, not in the yard, which is what I believe Ryan said, and also the side fences between the houses as well as on the retaining wall to indicate, in addition to the rental agreement that calls for that, to put the signage up around in addition to the vegetation on the back.
Chair, if I may ask a clarifying question?
Please.
One more time, explain, just lost my train of thought. Explain, you used the word sample for the rental agreement, but yet it was presented before that this is the rental agreement. So is it a sample, or is it a rental agreement, or what we saying is what is being provided to us today is the rental agreement?
I believe the way that it was presented in the application was a sample, a representative sample of what would be of the agreement that would be used. I think that, I guess what I'm suggesting is that we could adopt in the conditions of approval that that sample is the rental agreement that would be used for the vacation rental.
Okay, all right, and did we alleviate the clause then in that sample about the pets?
Yes.
Okay.
We would, yes.
Okay.
Okay, thank you. Additional questions for staff before we return to deliberations?
Excuse me, Commissioner.
Oh, Justin, did you want to say something?
Excuse me, I just want to make one comment on the rental agreement. I would probably suggest that staff use some sort of language of using the form provided with the application, or materially a form that contains the same material terms in case they go to a different provider, different form.
Got it. Okay.
So it'll be substantively that content.
Thank you.
Okay.
Chair.
Please.
Chair, I just had a question. The city attorney mentioned something about signage. I think I missed that part. What was the added information about the signage being put on the property?
As the property's been explained to me, looking at the aerial photograph with the applicant, I believe the signs, or there's fencing between all of the houses in the diagram you're looking at. The applicant has agreed to post signage on those fences to indicate no climbing. In addition, on the back, there's a retaining wall, the back of the house. I think the applicant has agreed to provide signage on that, in addition to planting some mature vegetation along the top of the retaining wall to dissuade tenants from climbing up on top of the retaining wall. The applicant has also agreed to put a term in the rental agreement that indicates no climbing on the fence or the retaining wall, so that she will have something memorialized with her customers. Does that answer your question?
Yes, thank you.
And I'll look to the applicant to see if that's accurately describes what we discussed.
Just following back up on what is or is not in the sample rental agreement. I'm looking at it right now, attachment 3, which is page 4, which is or 6.1, page 29. It says no pets policy must be observed. Pets are not allowed on the premise. So some elements of the sample rental agreement are things we're taking and some aren't?
As amended through our discussions.
Okay.
I don't think there's any question that that's coming out of the sample rental agreement.
Okay. And then two items above that is about maximum number of occupants shall not exceed 10 people, as was kind of discussed, but I'm also noting here it says, comma, not including a child in a crib. Any discussion on that? Sorry, I'm just seeing some of the details here, and it seems like we've been hearing a lot of different things and trying to know where we stand.
I believe the applicant has agreed to limit it to 10 people, including
I believe babies
babies.
shouldn't count on that, but I will defer to you guys on what you want me to do. It's your call.
I mean, it seems like a planning, decision for planning commission.
Yeah, great. I'm just still trying to, be nice if we had a sample agreement that was the agreement, not picking and choosing various things, and recognize that's not staff's issue, that's the applicant's issue.
You certainly have the opportunity to continue the hearing if you would like to have all of these things memorialized in findings and a sample rental agreement before you render your decision.
Thank you, I appreciate that. That, Chair Edge, that might be one of the things I'm most comfortable with.
What I was wondering is, if we were to, you know, kind of spell out the conditions of what needs to change in the agreement, and then as one additional condition to require the applicant to submit an updated agreement to the city that, you know, is, you know, it contains, you know, those, you know, substantive revisions. But maybe that, I mean, I don't know that that's actually necessary if we just condition, you know, just apply the conditions to the permit. So I don't know. I think that we can accomplish what we want to accomplish tonight just by conditioning it. But I'm open to feedback from the rest of the commission.
I'm sorry, Chair, could you just restate that one more time?
Rather than, so what I think we can accomplish what we want to accomplish by simply adding or revising the conditions of approval to include the specific terms that are concerning, that need to be changed in the rental agreement. And then we don't necessarily have to continue the hearing and come back and review an updated rental agreement that would be consistent with those conditions of approval. We just apply the conditions of approval, and the applicant, you know, then has to update the rental agreement to reflect those conditions.
So do we want to have a discussion of what 10 people are?
That's at our discretion. I suppose that's, you know, that's entirely up to us if we want to have that discussion or not. So if you do, feel free.
No, not at this point. Unless if we continue the hearing.
I mean, yeah, we have all of the options are still on the table. And if we prefer to see the information presented differently before we make a decision, then that's our prerogative. But I'm personally comfortable that we could address, you know, that staff has, you know, applied the, you know, has read the revisions into the record sufficiently. And if we want to come up with a, you know, decision about 10 or 12 or 12 if 2 are babies or, you know, whatever, that's up to us. Do you feel that we should, do you have a feeling about that, Commissioner Hamer?
I mean, I understand both points of view. I just want it to be as easy as possible. So if you say 10 people, I'm comfortable with the number 10. And if you just say 10 people, you count every human being in that building as a person.
Yeah, which I agree with. And I think the staff report, I think, says 10. I think the conditions or the findings of approval, I think, say 10. But then you look at the sample rental agreement and it says 10, not including babies in a crib. And so I think this is where I'm just kind of grappling with. I think we've moved around so many different things. I'd like to just have a clean document that says what it is we've kind of talked about, so that there is perfect clarity. That's what I think I'm hoping for.
Chair, if I may, if we were to continue the hearing, what date would we be looking at?
It would be December 13th, because we do not have another meeting before December 13th. Unless we opted to hold a meeting on November 22nd. Just for this.
But November 22nd doesn't give enough time to do all that to be able to send it back out to the public for review, right? I guess if we've closed the public hearing, then it doesn't really matter, does it?
I believe we're just bringing it back to you all for review.
Okay.
Yeah. I don't actually know. Is that, are we required to take ours? That?
Commissioner Sherman, do you want to review the House rules and identify where you have outstanding questions so that we can have clarity tonight?
Can I ask a question? Are you just kind of on the 10 versus baby language in the, is that
No,
what you mean?
no, that's not the issue. I mean, the issue is just I'd like to see a clean document that says this and this and this. So, it sounds like it's no climbing signs on the retaining wall and on the fences, planting mature landscaping on top of the retaining wall. It's saying the provision in the sample rental agreement that says no on-street parking is allowed, but it's saying the provision in the sample rental agreement saying 10 people plus babies isn't what we're saying. And it's just,
I believe you could say that.
sure, yeah. I'm sorry. I'm just being a stickler. We have like a document that says conflicting
I think
things.
you are doing an excellent job reciting what the agreement needs to say for
Exactly.
an appropriate condition for an approval.
Right, and then, right, so
Yeah.
we could do that.
We could do that.
So we could approve based off of those conditions.
If that is what you choose to have as your decision.
And I think those were the things, right, that we've kind of talked about. Is there anything else?
Right, and then
Did you mention the change to the pet rule, Commissioner Sherman? That was the only other, I don't remember if you.
And I don't even remember what the pet rule is at this point.
My understanding is that the rental agreement disallows pets. That is not actually, in fact, what the policy is. And so the applicant would like to allow for pets. So basically the sample rental agreement would be modified to remove that language.
Sure.
Right. So just a quick straw poll of the commission with those conditions read into the record. Who is ready to approve tonight?
I'm ready to approve.
I think I've gotten there as long as we're all on the same page about eliminating the babies in the crib language.
I'm fine with 10 people. It says 10 people. I'm fine with 10 people.
I can go either way on this one because I do understand, carrying a baby and it's not taking up a bed. So I don't know. A lot of places make allowances for kids that are in cribs or under 2. Like hotels and like lots of places make those airlines conditions. So are you guys?
Do we just not count children in cribs, or do we allow an additional number?
No, I don't think allowing an additional number is the right way to go.
So we would just not count children under 2 years of age or under 1 year of age. Is that what I'm hearing?
That's what Commissioner Ernst would like.
I would say, I think that it's reasonable to say 10 people and not counting children under the age of 2.
So allow it to read, now I got to find it.
Allow it to read what it says in the sample rental agreement.
Correct. Yeah, so what it says in the occupancy exceeding the sleeping capacity of 10 using the premises I think I'm at the right point. No.
It's restated in the rules a few different times, but under the attachment 3 on page 29 of the packet, number 4 is the maximum number of occupants shall not exceed 10 people, not including a child in a crib.
Well,
And
we
so
could
that
get real
language could
technical
just
about
stand.
this too. So that says 1 child in a crib, technically, right? I'm not going to argue. I'll let you guys talk about it. I think I've made my feelings known.
I think I'm fine with the language as it reads. That's as proposed by the applicant. 10 people, not including a child in a crib.
If staff can make a recommendation, I would recommend limiting it by age rather than a child in a crib. Seems easier.
You could have
Then I'm comfortable with Commissioner Ert's suggestion of 2 years then, not counting children under 2 years of age. That's what I heard you say, right?
Correct, yes. I think that's the standard for most places and airlines.
I'm comfortable with that. Other commissioners have opinions on that?
I'm fine with that language. With under 2 years old.
Well, that's a technical majority. How do the other two commissioners feel about that language?
Yeah, I'm fine with that. I'm frustrated we're making sausage at this moment and wish the applicant had spent more time talking with her neighbors.
Commissioner Humer?
Yeah, I understand the sausage. But I think we've got it set out. I would much rather see just the maximum occupant shall not exceed 10 people, period. Or it should read not including children under the age of 2, which then gets into something really sticky, which means that you could have 14 or 15 or 16 people there. So that's why I would like to just keep it at 10 people.
I'm okay with that.
Okay. Well, I don't, can we
It's fine.
say that the applicant
So I'd like to
said
propose
she's okay with that?
everything that I'd like to make a motion that we propose everything that we've talked about on the amendment, and including that in the sample agreement, it reads the maximum number of occupants shall not exceed 10 people. And now I got to find my deal to actually make the motion. I'd like to make a motion with those conditions for CU 2022-003.
Oh, go ahead. Or I'll second that motion.
Okay, so we have a motion to approve with the amendments read into the record and a second. Any further discussion before we vote?
Just a quick discussion, or not discussion. Can staff just maybe re-articulate at the highest level what some of those conditions are, so both the commission as well as the audience is clear?
Sure.
I will do my best.
Thank you.
So the application will be approved subject to modifications of the findings and the conditions of approval. Specifically with regards to the conditions of approval, modifications will be made to add language stipulating that the sample rental agreement included with the application is the rental agreement that is to be used. There will be a condition of approval added to address the retaining wall issue, climbing on the retaining wall, stipulating that the applicants place signage on the perimeter fences and on the retaining wall itself, instructing visitors not to climb on the retaining wall or the fences. In addition, to address the retaining wall climbing incident, there will be a condition requiring that the applicant provide to plant mature vegetation on the retaining wall to dissuade visitors from climbing on the retaining wall. And it will, per the sample rental agreement, which again will be mandated to be used as a condition of approval, no off-street parking is allowed associated with the conditional use.
Sorry, no, on street.
Oh, on street. Thank you, Commissioner Edge.
Thank you.
And crossing off child.
And in addition to that, we will condition that the rental agreement is amended to remove the language that disallows pets to reflect accurate policy, and that the language in the sample rental agreement around that allows for children in cribs, that language will also be stricken from the rental agreement.
Thank you, staff.
Okay, so that's what we have on the table. Any other clarifying questions or discussion before a vote?
And the 6A fix or whatever.
And in addition, yes, the findings will be amended to reflect the relevant comprehensive plan, goal, and policies.
Perfect. Thank you. Okay, I'm going to poll the commission. All those in favor of the motion, raise your hand and say aye.
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 Aye. And that passes unanimously. Thank you all.
There we go.
Okay, so proposal or application number CU-2022-003 is approved unanimously by the Planning Commission. If anyone wishes to appeal this decision to the City Council, you must make application stating the grounds for your appeal within 15 days of the mailing of the notice of decision. Please see planning staff for details. Now we're on to work session items. So this is the code amendments for the climate-friendly and equitable communities. This work session item is a discussion about the proposed updates to the Milwaukie Municipal Code to conform with climate-friendly and equitable communities rulemaking. Take it away.
Thank you.
Thank you, guys.
Thank you, everybody.
You ready?
Yes. Hold one moment.
No problem.
Okay. Can everyone see the presentation on Zoom?
Yes.
Yes. Great.
Probably should have stay.
Okay, so I would like to start just by apologizing. Preemptively, staff had intended to bring some complete code language to this work session. As we dug into these issues, we realized that some of the changes were a little bit more complicated than we had anticipated and needed a little additional time to work through some of those. So I'll discuss what those complications were in this presentation. I just wanted to.
Always complicated.
Some opportunities to write better code.
Page left.
Hi, Justin. So just to remind everyone, some of the prior actions that have kind of led to this point include the Climate Action Plan, which was adopted in 2017, the Comprehensive Plan, which includes many goals and policies related to climate change and reducing greenhouse gas emissions, was adopted in 2020. Governor Brown issued an executive order in 2020, Executive Order 2004, that eventually initiated the climate-friendly, equitable communities rulemaking that the Department of Land Conservation and Development undertook. Then in August of this year, we went to City Council to inform them of what some of those, what that rulemaking meant for Milwaukie. And then we brought a similar presentation to you all the next month to update you on again, what the climate-friendly equitable communities rulemaking meant for Milwaukie and what City Council's directive was specifically regarding the provisions and the rules around parking minimums. So included in the staff report, there's some underlined strikeout code amendments. Those code amendments do a few things. They remove minimum vehicle parking requirements. They also remove all references to minimum requirements in the code. And in addition to that, while we were in section 19600, which is the off-street parking and loading section of the code, we made some minor non-substantive or related really language changes just to reflect consistency within the code overall. For example, language around changing single-family dwellings to single detached dwelling. Those changes had been made elsewhere through the middle housing code updates. We just changed them. They had not been made in this section, so we made those changes. The two areas where there are not complications but opportunities to propose better code relate to rules around large parking lots. So the rules basically require new surface parking lots that are over a quarter acre in size to comply with some specific standards. And then in addition, there are some new rules around bicycle parking. Those we do not have to comply with. I'll say the large parking lots, the city does have to take action to adopt code language by June 30th of next year, 2023. For the bicycle parking, we don't actually have to make changes to our code technically until a major update of our transportation systems plan. We are, as you know, going through that process soon. But I will say that because we are removing minimum parking mandates in our code, the current way that we calculate the required number of bicycle parking spaces is based on the required number of automobile spaces. So removing that language from our code basically creates a situation in which an applicant could apply for a new development and not have to basically provide the amount of bicycle parking that the city might like to see. So going a little bit deeper, not too deep, on this quarter acre surface parking lot requirement, and I will try to move here, see if I can navigate this so that everybody can see. Builders have three basic options if they're going to be providing a quarter acre parking lot. They can either, they can install solar on the property or pay a $1,500 fee in lieu per parking space.
That's a good one. I joked. Sorry, I said that's a good one.
Oh, it's okay. It's so the DLCD issued some guidance on this particular set of rules on Friday. As I understand it, there's currently, the city does not have a fund to accept that fee in lieu, and the Department of Energy, which if you read the language closely is an alternative fund that folks could pay into. It is unclear whether that DOE fund could accept these monies. So all of which is to say there is no current proposal language in the staff report, and it's unclear if this specific provision will eventually be included in our proposal because of this lack of clarity on whether or not we could even accept or builders could pay that fee into any fund. So as an alternative, builders could take actions to comply with this administrative rule. This really only applies to public projects. It's a percentage of the overall cost of a project has to go, as I understand it, towards clean energy. So if there was a public project that was providing a parking space of that size, if they take actions to comply with that specific administrative rule, that would satisfy this requirement. And then finally, there is an option to provide at least 50% tree canopy coverage on the parking lot at maturity or at least within 15 years of planting. So currently, staff are working with as you know, we recently adopted a residential tree code. A lot of the standards in that residential tree code we think will be applicable. They reflect best practice and will be useful to essentially point to so that builders choosing this option will have sort of clear and objective criteria to meet this requirement if they're choosing to go with option C. So we're working on that code language currently. Just to give you some perspective of what a quarter-acre parking lot looks like, the parking lot across the street from City Hall is much larger, definitely over a quarter acre. In addition, the Leading Library parking lot would have to satisfy this requirement. So just to give you some sense of, the scale of projects that would need to comply with this new rule.
I'm sorry.
Go ahead.
Ryan, can I, before we move on, we're not getting rid of the max number. Right, we have minimums and we have maximums, right?
Yep.
And so we're not getting rid of the maximum number. So there is a cutoff on how much parking that you can do, right?
Absolutely. Yep.
And then it seems like 50% of the tree canopy is going to take up 25% of the parking available. I mean, you need a tree that's about 12-inch in diameter every so far to cover 50% of the parking lot, which means that you need a wide, I mean, we could plant an oak tree and just let it grow up through the asphalt like out here at City Park or across the street, but.
Right, and in that, I will say that the within 15 years of planting aspect of the rule as well also creates an additional wrinkle of not complication, but interest in developing appropriate standards here. This is where we're working with our urban forestry team to basically, it's quite useful that through the residential code, we have this 40% requirement for the site because our urban forestry team created a list of trees, and that includes at maturity what they expect that canopy to be. They have proposed, and I think this is the direction that we're heading, basically creating a separate list of trees that would specifically meet this administrative rules requirement to provide to builders. It could take up, I hear that your concern is more about like, is it?
Well, there's a lot about, right? Because you have a street light requirement as well. And so if you have a large canopy that basically blocks the street lights, then why do you need the street light? You understand what I mean? There's a lot of kind of things that kind of.
There's a lot of components, and there's to kind of work into the design. I think if I could speak on the DLCD's behalf, I think that they believe that it's possible. I know that the guidance that came out on Friday spoke to that issue, specific like that you're in your site design, you're incorporating a lot of different elements, including lighting. And I know that at least when it comes to in discussions with our urban forester on the achieving 40% coverage for a residential property, that standard can be met through basically planting something like 3 oak trees. I mean, it depends on the size of the lot that we're talking about.
Right.
But it's not necessarily as many trees. Now for this, because of that 15-year timeline that we would have to meet, it could be that you're using smaller trees that are more closely packed together. Yeah, I don't know if that exactly answers your question about.
No,
it's complicated.
But thank you. Yeah, it's not impossible.
Sorry, it's not impossible.
It gets really complicated when you start thinking about it.
It's more. It requires more intention and design than maybe projects in the past have had to.
And I'm assuming that we have some sort of standard for height of what a light pole has to be, right?
We have lighting standards in 19600. They're I'm guessing that I don't know if there's a specific height standard. There's definitely standards around how that basically limits their impact to surrounding properties.
Right.
So I think that would factor into that as well.
What are we looking at right here? Like percentage wise, or what is that projected? Is that?
We're not, in terms of tree canopy, I couldn't tell you. We're not looking at much. And I'm not even sure that, actually I won't get into that. Yes, we're not looking at much, definitely not looking at 50%.
So what we're talking about though is requiring a parking lot like that to get to 50%.
That is one option. I can speculate safely, I believe, that this project actually, because it was a public project and is providing those solar panels on top, that they would not have to, that they would satisfy this administrative rule because they had to comply with that other OAR rule. Administrative rule.
Okay, so the tree canopy coverage of 50%, if somebody can't comply with that, then they go more in the direction of providing solar panels or the other options.
Correct. Yep. They have other options.
And we can write those into the rules and adapt the OR whatever rules, right, for non-public projects, non-governmental projects.
That is the process that we are currently going through. I had hoped to have complete by this meeting, but we're not there. And really because of trying to get right those, working with our urban forester to make sure that we have a clear way for builders to meet those requirements. Any other questions on the large parking lot rule?
On the large parking lot, are we also considering any kind of performance standards, making sure the trees live for a certain number of years?
We are. The rules actually require that we do that.
Great. Is there anything else around kind of the actual physical space for the tree? You know, a planting area of at least X cubic feet?
There will, So we're thinking that the rules also require that. And we're thinking that pointing to our soil volume standards and our residential tree code provides a good framework for achieving what the rules require.
And I think that the framework makes sense. I would anticipate maybe it's larger soil volumes for these bigger trees that are getting to 50% of the parking lot.
It might, and that's where it will actually, as I understand it, not being as well versed in the residential tree code as I would like to be, working towards that goal. It's somewhat dependent on the specific tree. And so we have, Urban Forestry has created a list of approved trees, sort of to help people get to that 40% canopy. And in addition to that, there, with those materials, there's soil volume requirements as well.
Okay.
So.
Couple questions. One, I guess I don't think that this would be part of the city code, but safety is also, I guess, part of my thought process or concern on this. leaves tend to make things more slippery. They just do. So I'm assuming that then it would increase the responsibility for them to somehow make sure that the leaves aren't just piling up. And then also, does that increase the cost on the city as far as making sure that the drainage?
Yeah, those are great questions. I don't know if that wouldn't, I would guess is not something that would be included in as part of this code amendment package, and that those are requirements related to upkeep of your property and parking lots and stormwater management live in other parts of the code. I don't know if
someone could also plant conifers if they didn't want to deal with leaves. They could plant trees with needles.
True. I don't know if it might be more challenging to get to that canopy, that 50% canopy, but yes, there presumably would be other options. Yeah, those are great questions, but yeah, I think it would probably, any requirements would live outside of this section of the code, if that makes sense. I think Public Works probably has.
Yeah, well, you have a storm drainage
Developer
standard.
also isn't going to necessarily maintain a tree leaf laden messy parking lot because of potential liability issues.
Right, that they're going to be
just general
forced to
upkeep
do it,
and things like that. Yeah.
Or it's just going to be a slimy, muddy mess.
I'm just saying, like, looking at it from the impact too of the people that actually live and walk on these I mean, I'm all for planting trees and trying to push the requirement. And also I like kind of trying to encourage more people to adapt into solar and alternative energy. So I like that there's a amendment for that or condition for that. But there's practicality challenges to planting trees everywhere. We've saw it during the storms and we don't have our power grid underground, so it wipes out power to everybody. Increased forest fires, which I know also this was what we're talking about climate-wise, but we have seen entire neighborhoods in California burn because of the type of trees or because of how much tree coverage they have in certain areas. So, I mean, there's just a lot of factors, I think.
Yeah, agreed. And I think, one, I would just, I guess, reiterate that to some extent, we don't have much, we have to do this. This is required. Two, I think that, this administrative rulemaking was happening during 2020 when we had the heat dome. And I think that there was a lot of attention really paid to areas in the region that had been paved over, that had a lot of asphalt, and where temperatures were multiple degrees above. And so I think it is a climate mitigation, but yeah, you're right that there are other complications that might come along with the implementation of this. Lastly, I guess I would just say that there's another rule that does require for these large parking areas, and our code already requires this, so it's less impactful, but that these large parking lots incorporate street-like design, so essentially pedestrian infrastructure, so sidewalks that allow people to traverse these areas safely. And so maybe that also hopefully gets at some of your concerns around people sort of safely navigating these spaces where more trees have been planted. I understand the sidewalk can also be slippery, but
it is more, when I go on my walks, it is more slippery when there are leaves covering all over the sidewalks. Yeah. That's just, it is. And then it also increases the cost as far as drainage and, a whole bunch of things, which, it's okay. It's just something to address.
Yeah.
Well, the trees will drink more stormwater than not having trees, so it should mitigate the volumes of water that our storm systems have to manage. I had one more comment on the large parking lots if we're getting ready to move on.
Please.
So if we, in our current comp plan, if we look at policy 8.2.2, which are our parking design policies, we've got sub policy B, which basically says plan for the potential conversion of parking spaces, including conversion of existing private and public parking lots to other uses. And so what I would encourage us to do when we're looking at drafting our code for things that are getting built for the next 20 years would be to make sure that the parking lot area, that the design standards for the parking lot areas for these larger parking lots are set up to require them to be arranged on the site in a way that allows that parking to be redeveloped with other uses at some future point, if that becomes a better use of that land.
That's a clever statement.
Yeah, noted. Yeah, okay. I'm familiar with that concept. I haven't necessarily seen how jurisdictions haven't adopted that into their code language, but yeah, we'll look into that.
Excellent, thank
Laura
you.
will figure it out. Laura's on it. We got a funny facial expression out of her on that, Joseph and Josh.
Anything else on large parking lots before moving on to bicycle parking?
Not from me.
Okay. Great. So as mentioned, there are new administrative rules around bicycle parking. We, again, do not have to make those changes to comply until we update our TSP. The reason that we're really looking at this section of the code right now is because of the removal of minimum parking quantity requirements for automobiles. But just to sort of cover what those new administrative rules will eventually, when we update our TSP, require us to do, I sort of listed the key takeaways. And I will just say that for the most part, our code already complies. So we have to have a 1-for-1 bicycle parking space per unit for multifamily and mixed use developments. We have to require bicycle parking at transit centers. With the amendments, we will comply with the requirement to require bicycle parking in Metro 2040 town centers and at key destinations. We likely already we do already comply with the Metro 2040 center requirement. That is basically downtown in some of our mixed use areas. But this language is specifically reflected in the administrative rule, and through the proposed code amendments, we adopted that language just to demonstrate compliance. And in addition, there are some design requirements for what bicycle parking needs to look like. Our code already complies with that. And the one thing that we don't currently require is sufficient space for cargo or family bikes. We haven't quite figured out what that language should look like, but that's something that we're looking into. Yeah, so again, just to reiterate, the changes that we're working through that are related to CFAC are the quantity. How do we determine how many bicycle parking spaces are required, and the changes that we are looking into that aren't really stemming from the climate-friendly Equitable's rulemaking are some clarification in our code around short versus long-term bicycle parking, and in addition, improving our requirements for bicycle rack design. So quickly, just looking at quantity requirements, some of the research that we're doing, what other jurisdictions, how they make this calculation. Again, most jurisdictions around the state currently, from my limited research, they basically do it the way that we do. It's based on a percentage of automobile parking spaces required. But there are other ways to do it. The city of Portland recently updated their bicycle parking requirement to include factors like employment density. We could use building occupancy, development square footage, and then looking, sort of taking those, I guess, site-specific characteristics and looking at other factors such as the percent of trips taken by bike, both currently in the city, which for Milwaukie is pretty small, and what the actual goal is. So Portland's got a pretty ambitious goal for how many trips they would like to be seen taken by bike. So other factors we could consider includes rates of bicycle ownership. I think grouping it by by the actual land use is best practice and what everybody does. And then geographic distinctions between maybe you have higher requirements for places where people bike more. That's something that the city of Portland has done for their central city. They essentially have they require more bicycle parking. So again, the quantity requirements is something that we're looking into because we're removing the required vehicle parking. Things that we don't necessarily have to do, but we have come to see as shortcomings with our current code. We implicitly make some sort of distinction for short versus long-term parking for residential uses. We require that 50% of the required bicycle parking spaces that you have to provide, that they be enclosed and covered when 10% or more of vehicle spaces are covered, if you're providing more than 10 bicycle parking spaces, and for multifamily residential developments with 4 or more units. A lot of codes make a much more clear distinction between short versus long-term parking. Long-term parking, again, being, as you can see, something that is enclosed and secure. It's covered. It's intended for people who are staying typically more than 2 hours at a site, and short-term parking being something that you're going to see on the sidewalk. It is intended for short trips, less than 2 hours, accessible to the public, isn't something that's necessarily covered or secure. Or it's less secure, I will say, than long-term parking. So again, we do to some degree make a distinction in our code, but we do not use these exact terms, and it does seem to be best practice in development codes around the state and elsewhere. The professional literature also recommends having this distinction drawn out in your code. As I understand, it's also presented some sort of a challenge when reviewing development applications that we don't necessarily have clear and objective standards for where required bicycle parking needs to be placed in a development. So I've heard from other planners on staff that that's posed a challenge, specifically in addressing some of the new multifamily developments that we've seen in the city. Where does that bicycle parking actually need to live within the development itself? So hoping that some code amendments providing this distinction and being more clear about where we would like to see that bicycle parking. And then finally, rack design. Our code currently requires that you be able to, through your bicycle parking, lock the frame in one wheel. Technically, you can achieve that standard with a lot of what I would describe as less than ideal bicycle parking. So the wave rack, I think, is mostly what we've gotten from developments. The big shortcoming with this style of rack is that it doesn't, if used as intended, it does not allow for 2 points of contact on the bicycle, which is why you get sort of the situation that we have in the top right-hand corner. You've probably seen a rack like this with bicycles basically on the ground. In addition, both for the wave rack and for a schoolyard style rack, which also technically meets the letter of the law in our code, if used improperly, you can get 2 points of contact, but you're really reducing, in effect, the number of bicycle spaces that you're providing. So we would like to move away and update our language to basically require the inverted U. The city of Bend recently updated their code just to say this is the bicycle rack that we would like to see. It provides all of those sort of features, 2 points of contact, a secure way to lock your frame and your wheel. We would like to, the proposed amendments that we have address this issue by saying that this is the rack we would like to see. And that is the end of bicycle parking. Any questions on that? Thank you all for your attention on what I know is late nights and this is pretty dry stuff.
One of the things
I don't usually.
Go ahead, please,
Oh,
Joseph.
go ahead. Okay, so I usually don't jump in first, but I want to jump in first this time. What I think we should do in terms of the quantity, the minimum required bike parking would be to work with the policies that we set in our transportation system plan around mode split. Whatever our mode split target is for share of trips by bicycle, we should look at the probably the ICE's trip generation rates for the uses that are proposed, and then whatever percentage of those trips that our TSP says should be made by bike, we should make sure they provide enough bike parking to satisfy that goal. It seems really intuitive to me that we would take that approach and make sure that the private development is actually providing enough bicycle parking to facilitate the amount of bicycling that our policies are calling for.
Sure.
I was glad to see that in your list of possible approaches, and I think that's absolutely the right way to go.
So Chair Edge, just in a question around that we will not be doing the TSP and we won't know the mode split and we don't know what our goal is going to be. So we're going to need some sort of interim solution. So I just wanted to throw that out. So we may have to come up with an interim solution and then come back when we have adopted the TSP and update that and have a different conversation.
Yeah, and I guess that's that was where I was lacking a little bit of clarity. On the 2013 adopted TSP, I see references to the mode splits required for different Metro Region 2040 design types, but that's really just the non-SOV mode split that we're looking for, that target. So we didn't actually adopt any specific split targets as part of that process, even though it says that there's a policy in here that we should do that as part of that plan.
I don't know that we did.
Okay.
We would probably want to check with the engineering.
Yeah, but I think my gut is telling me that we probably didn't, but we can look into that. So.
Yeah. Okay. So we do have a policy on the books that says we were supposed to adopt mode split targets. So hopefully we followed through with that to some level and could rely on that as a target.
We'll look into that.
And it certainly sets us up, if we were to do something like that, it sets us up to, change things when the new TSP is adopted in a couple of years. But
yeah.
Any other questions or comments from the commission?
Thanks, Chair Edge. I was going to say on long-term bike parking, I think one thing that would be useful is also making sure that there are electrical outlets located nearby. Thinking about people who use e-bikes, the opportunity to be able to charge their e-bikes while they're parked at those long-term facilities, I think would be really valuable.
And if you want a type 1, type 2, or type 3 plug with that?
And just
Everyone should do it.
yeah, tight, yeah.
With you wherever you go.
I think most cyclists will probably take their bikes with them, assuming there's room on
Well, I
transit.
guess that's the other
But
question.
I think that the issue of secure bike parking at transit is
Big
it's
issue.
well, and it's also, I'd say, somewhat of a moot issue. Like our system's built out here, right? Like I don't see us getting other transit stops, and we have, at least at thinking about over on Tacoma and thinking about down at Park, there's secure bike parking at both of those facilities.
Is it considered long-term or short-term?
It's long term, yeah.
It's
You can
gotta-
park there all day. I mean, it's secure too. You have to like have a special pass to get in and all of that.
Well, I was
So-
just wondering if that's something that is also important that at major transit stops that we think about, putting in longer term. Or I get that's why
Yeah, I
asked
just
the
don't know if
question.
we would get in the next 20 years get any new major transit stops.
Well, or you could, if it's required, then you could, put one at Jackson Street if you wanted to, right? Without having to go through a whole bunch of rigmarole about downtown design and everything else, right?
They'd have to figure out how to put art in the secure bike parking.
It'd be
right?
easy. It'd be easy. Just
It's so easy. Just say it and it'll be done.
That's right. I'll stand on top of it if you want me to. Call me Art.
Oh, and but to speak to Commissioner Hemer's question, just from a different perspective, for me, it would depend on what my destination was. And so if I wanted to ride my bike from my house up the trolley trail to Park Avenue, and then at the other end of that transit trip, I'm going to be, just walking a block or two to my destination, then it might be more convenient to just leave the bike parked in long-term storage at the transit stop to help me with my last mile connection at this end of the transit trip, especially if I don't need it for the other end. But if I'm going out to, say, Nike or something in Beaverton, then I probably want to take my bike with me because I'm going to get off at 158th or whatever. And I'm still going to be a mile away from my destination. And so I'm going to want the bike there. You know what I mean? So it really depends on the journey. And people might make different choices on different days, depending on, where that journey takes them.
Okay. Yeah, I'm to answer the question about how much bicycle parking, right? I'm actually fine with the 0.5 per unit, just like what we did with the automobile, right? And how you set your parking standards, right? I think that's what we use for downtown, right? A 0.5 or a
1-to-1 on the, for bicycle and residential.
Yeah.
currently we're
Multifamily.
1-to-1 on a unit.
And we have to at least require 1-to-1.
Oh, I'm sorry. All right.
Yeah.
I apologize.
And and that's, for residential, I think a big sort of gap in removing minimum parking quantity requirements is that for industrial, commercial, and like community service use projects, we would not know how to do that calculation. So the residential multifamily mixed use development with residential, that's covered in our existing code. It's because we're removing vehicle parking that for those other land uses, we wouldn't know how to make that calculation with our code as it currently reads.
Right, that's what we have to solve for.
That's what we're trying to solve, yeah. Does that make sense?
Yeah, I guess you could do it by a certain percentage of employment,
Which is, that's
right?
one.
Like 25% or
Number of employees, square footage, this sort of mode share goal is a component that Commissioner Edge was talking about. That's something that Portland includes. They include both of those things, actually, mode share goal and also employment density, or like the square footage per employee. They've got a more complicated way of getting at it, and then different goals kind of based on the area of the city that the development's occurring in. So there's a lot of nuanced ways of trying to get at what the right number is And that's kind of the work that we're trying to do right now, is understand what those different options are and then what's best for Milwaukie.
So if I owned a warehouse, right, or I build a warehouse, I guess I don't necessarily know who my tenant is. So right, if I were to build one, how am I supposed to know how many employees?
Do it by square foot.
Which is, square footage.
Because it changes, right? So whoever's in that building might change.
Right.
So the thing that doesn't change is how many square feet the building is.
But just to say it, when we require a transportation impact analysis, so when, say, a warehouse is going in, if it, is going to create a certain number of trips, right, then they have to do a study. Well, how do you calculate that number of trips, when you don't know who the tenant is? Well, you have the ITE trip generation metrics to go for land use codes. And they have different formulas for calculating the number of trips that a different type of land use will generate, depending on what land use activities are occurring there, and then some other multiplier like square foot or, square footage or, number of residents or, whatever, right? So I think that's kind of the standard that we already use for determining transportation impact by different uses. And that would seem to be an intuitive base metric for, arriving at the number of bicycle parking spaces that we would need to facilitate that use. So I would just argue that, I know I complain about the trip generation rates a lot, but, that's kind of the standard way that we estimate that kind of impact on the transportation system. So that's why I would lean towards that.
On a slightly different, on the same topic, but a slightly different element of it, and one that we haven't talked about, aside from thinking about the long-term parking requirements, is there an opportunity to also think about like shower facilities as well? I recognize that might be outside of the scope of what, initiated this, but just knowing that, creating an opportunity where employees are able to shower after their bicycle commute might be an interesting thing. And maybe there could be an opportunity as well, thinking about some of the EV readiness work where, we're setting a high performance threshold, but then creating a incentive to see things built. Maybe there's something to think about there. I know some cities do make those requirements. And that might also get, I don't know if that's anything that we're doing. And again, it's probably outside of scope on this, but it's just be interesting to think about, because I think that the bike parking and some of those additional amenities kind of go hand in hand to reaching those mode shift goals.
I'd agree.
Good point. I agree with that. I think we should look at it. It may not be part of the climate friendly, rules that we have to implement, but I'd consider long-term bicycle facilities and amenities to be in scope for this update.
It's what might get you on a bike, Greg.
Yeah, well, so this relates to you, and since there's nobody really watching in the audience, I will tell the story live. I was talking to the police, and we were talking about the scooter thing, and I said, well, if you ever see me on a scooter, you should probably really pull me over, because I've had way too much to drink to get me onto the scooter. So it's probably almost the same thing with the bicycle. But I have been walking my dog more, so maybe I will get into some sort of shape.
And with that, any other questions?
I don't think a shower is going to get me on a bicycle, though.
I just want to say with that, shifting things around a little bit, because right now we have the hearing scheduled for this on December 13th. And I don't think that we're going to be ready for a hearing. I think that we're going to need to come back in another work session because obviously there's still some questions that we haven't worked through. We haven't worked through, and then we haven't worked through them with you all, obviously. So I'm going to change the hearing on the 13th. I'll probably push it to the 10th or even the 24th after I look at the schedule. So that's just a heads up for you all.
24th of January?
Yeah. And I will.
We technically don't need to take any action by the 31st. We simply need to stop applying the minimum parking rule.
Correct.
That's right.
After the 31st.
Yeah.
To new development reviews. Yeah. Okay. Okay. Yeah. So there's, I guess that's a good, we can take a breather on that and make sure we get the code right before.
Sounds like we're working our way out of a meeting on the 10th, huh?
Working our way out of a meeting on the 10th? Not necessarily.
All right.
I'm going to look at the schedule, but not necessarily.
Let's see. While we're still here, do we have any other questions or comments on the climate-friendly and equitable communities parking? Anything else for Ryan? All right, cool. Well, thanks, everybody. Thank you, Ryan.
Thank you.
Did you have any other specific questions for us before we move on that topic?
Nope.
I don't think so. No. Again, thank you for
All right, cool.
listening.
Okay, so we have
Engaging.
a hearing 13.
Excellent. So do commissioners have any other items for discussion?
Chair, if I may.
Please.
So I believe at our last hearing when we were trying to pass the legislation for the downtown code, we closed public hearing and we went into deliberations. But since on the 24th of January, we're going to be bringing in hopefully a really large piece about public art that we could reopen up that hearing for public comment.
Okay.
And I don't know when procedurally that has to I don't know if it happens right then and there, but I don't want people to miss out to be able to comment right the 2 weeks prior. So I'm not quite sure how that works.
Okay, I'll do that.
Yeah, I think it would be nice.
Okay, I will look into that.
Any other items for discussion?
Sorry?
Any other items?
I don't have any other items for discussion except for I still got to do the forecaster. Sometimes.
Yeah, all right. Yeah, the forecast. Take it away.
Anyway, so we've just got one more meeting left this year. And so we will have the draft housing capacity analysis. We'll be having our consultant from Eco Northwest coming to talk to everybody about what we found through that analysis of housing needs in the city of Milwaukie as a precursor to developing the housing production strategies, which we're also in the process of doing with our housing capacity technical committee right now. So that process is going well. And then we will have a hearing item, the Alpha Stoneworks variance to the design standards and the MUTSA. And then we will have another work session on the topic that we just discussed.
And I'm pretty good at acronyms, but can you remind me what MUTSA stands for?
It's the Tacoma Station Mixed Use Area.
Great, thank you.
That's it.
Excellent. I will entertain a motion to adjourn.
Well, since Chair Losfeld isn't here, we should probably do that quickly. So
Yeah, really fast.
I move we adjourn.
I'll second.
I got a motion in a second. All those in favor, raise your hand, say aye.
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 Aye. I guess we're unanimous. Let's go. Have a great night, everybody.
Bye.
Bye, thank you.
Good night.
Thank you.
Bye, Josh. Bye, Joseph.
Night.